correct?
It is part of our responsibilities. Yes.
And the level of seriousness increases dependent on the position that a public servant holds. In this case, a low-level administrative data entry individual is vastly different in terms of the serious scale than the vice president of the CBSA when you reference deleting emails. Would you agree with that? When was the president, Aaron O'Gorman, informed about Mr. Doan's deleted emails?
We have not concluded that there were any deleted emails.
When was she informed, sir?
She was informed of the allegations when I received them.
Of the deleted emails?
The allegations as I received them.
When was it?
December 11th is when I received them. I can't recall exactly which date I would have.
When was the Auditor General notified of 4 years' worth of deleted relevant emails?
Again, one point of clarification, I have no evidence that there has been deletion at this point. We are looking into the matter.
Can you answer the question, Mr. Lafleur? When was the Auditor General notified of 4 years' worth of a Vice President's deleted email account? When was she notified, and by whom?
So I can say that during our various engagements with the Office of the Auditor General, we have provided them with all of the information that we had available.
Did you inform the Auditor General yourself, sir, or someone under your control that the Auditor General received evidence of 4 years' worth of deleted emails by Min Doan, Vice President? Yes or no?
Again, I'm not sure what you're referencing. I did meet with the OAG.
Chair, can we get some clarity, please? My questions are very direct.
Yeah, Mr.
And this
Lafleur,
witness has a
we
hard
do ask you
time.
just respond and just a direct answer, please. If it's a yes or no, please a direct yes or no, but otherwise a direct answer so we can move on.
Did you notify the Auditor General of 4 years' worth of deleted emails?
I notified the Auditor General that I had received allegations to that.
And when did you notify her?
In December, after I received the allegations.
December of 23?
23.
Okay. Was the Treasury Board Secretariat informed?
No.
Did you inform the RCMP of potentially 4 years' worth of highly confidential, relevant emails?
We are required to report potential criminality. I have no evidence of that at this time.
Thank you, Mr.
Wow. No evidence
Okay, that
of
is-
potentially
that is our time, Mr.
deliberately
Brock.
deleting emails, and that is not criminality to you?
Mr. Brock, that is our time.
Wow.
Mr. Baines, please go ahead.
Thank you, Mr. Chair, and thank you, Mr. Lafleur, for joining us today.
Ask if it's confidential.
So the statement of fact, which we've been talking about in the last few line of questioning here, is that confidential?
It is.
So the witness sharing it with a member opposite, is that some type of breach of any sort?
I'm not aware of any sharing that would have occurred.
Well, Mr. Chair here had confirmed that Mr. Brock received it from a witness. So would that be a breach of any sort in this investigation? Is this in a way undermining the investigation that's ongoing? Are they supposed to be talking about this?
I would say it depends on who it came from. Obviously, I would have concerns if that had come from a member of my investigation team.
Well, the Mr. Chair here just confirmed that it came from a witness, that Mr. Brock directly received it from one of the witnesses. Which witness, we don't know.
If it was to somebody who it was provided and it may be considered their personal information, they are free to share it as they see fit.
Okay, so it's there, but it's confidential. Then you just said it's confidential. You can't share it, but a witness can share it?
If it's about them, they
Right, okay.
could share it.
So in the scope of your duties, are you concerned, you mentioned that there's been some things, some systemic issues with respect to contracts and documentation and these sorts of things. Are you concerned within your investigation now and you're uncovering things, you're finding things, if there's widespread corruption in your organization?
I've seen no indication of widespread corruption. We provided information to the president in the fall of 2023 after which she took a number of measures to strengthen procurement within the CBSA. I'm comfortable that those measures are serving their purpose.
So this incident specifically that you're seeing, is this like the first of its kind that sort of, in a way, like we've been extremely confused. It's been like a tangled web, and there's still a lot of clarity that needs to come forward here. So is this an isolated incident in your time that you've seen?
It is the first time that I see a file of this complexity and seriousness relating to procurement, yes.
Okay, so if you're looking at like the Treasury Board guidelines for discipline, like in which circumstances might public servants' presence at work undermine or impede an investigation, as described in the Treasury Board's guidelines?
So I can speak to the Treasury Board standard on security screening, which outlines when an employee may need to be suspended. And speaking generally, it's when they would represent a potential security risk to the organization, to people, information, or assets, or to the conduct of the investigation. So again, speaking generally, if someone is under investigation in the workplace and still has access to witnesses, they may try to influence them, so that would be a concern. So they may be removed from the workplace to protect the integrity of the investigation.
So, seeing how Mr. McDonald and Mr. Utano are suspended, like, is this one of the risks that you thought that or CBSA is seeing, that they may have access to information, and that's why they've been limited to that access and been suspended?
So Mr. McDonald and Mr. Utano are not employees of the CBSA, so I can't speak to the decision to remove them from the workplace. I can say that generally speaking, it is normal in the course of an investigation for management to assess whether there is a need to mitigate potential risk pending the conclusion of the investigation. In the case where they have identified a potential risk, they have the responsibility to ensure that temporary measures are put in place to protect the organization, to protect the workplace, until an investigation is completed and final decisions can be taken.
There's been, we've received some feedback from some of the witnesses that have appeared here before, and they've declared that there's some challenges with their health, that they're unable to come back. Has this limited your investigation in any way?
I can't speak to any discussions that we may have had with potential witnesses. I will say that I have great sympathy for the stress that anyone involved in an investigation, whether it be a witness or someone who is under investigation, may face, particularly with the level of public scrutiny that this file has had. I can appreciate how that is extremely stressful.
Gentlemen, Mr. Genlis, please, for 5.
Thank you, Chair. Mr. Lafleur, you're tasked with providing an investigation internally into what happened with ArriveCan. I am interested in what seems to be the difference in the level of interest you're applying to allegations against different individuals. Your preliminary work at least seems to suggest a profound interest in allegations against Mr. McDonald and Mr. Utano, and a surprising lack of interest against Mr. Doan. I note that Mr. Doan faces serious allegations related to the deletion of documents, and that no provisional action seems to have been taken against him, while Mr. McDonald and Mr. Utano have been suspended without pay. Could you provide the committee with any explanation as to your relative much greater attention to allegations against Mr. McDonald and Mr. Utano compared to allegations against Mr. Doan?
I would disagree that there's been an undue attention given to one over the other. We received allegations from Bottler AI in November of 2022. It would be expected for that investigation to have proceeded much further than new allegations that I received in December of 2023.
Okay, so your explanation is that you received the allegations against Mr. McDonald and Mr. Utano earlier, yet Mr. Utano and Mr. McDonald received a letter notifying them of the allegations against them on November 27th of this year. That was, again, suspiciously 20 days after their damning testimony before this committee. How are we to understand the fact that allegedly your investigation had been going on for a year, and yet they received a letter notifying them of the investigation in November of this year?
If I can have a minute, perhaps, to explain that timeline. So we did initiate an investigation in November 2022, considering the potential criminality. When we have interactions with police, we do respect the integrity of their investigation. And in this case, we could not proceed with interviews or with notifying the individuals under investigation with respect to the RCMP investigation. So since we're talking about the same witnesses, the same evidence, we were limited in how we can proceed without negatively impact the RCMP investigation. That scenario changed when the Globe and Mail issued their report on October 4th of 2023, and holding back on our investigation became a moot point at that point, which is why.
And yet it was still after their testimony on November 7th. Like this, even what you just said doesn't make any sense from a timeline perspective, because the Globe story that you referenced was the beginning of October, and yet it was only after their testimony before this committee that they subsequently heard from you that they were under investigation. This whole thing is just bizarre in terms of the investigation, because you said investigation started a year ago, but somehow it was only within a couple weeks of them coming before this committee to give damning negative testimony about the government in response to questions they were asked, that they were told that they were under investigation. They were subsequently suspended without pay. Meanwhile, we have these very serious allegations against Min Doan that involve hiding information, deleting emails, and as far as I know, there's been no action taken against him. The clearest difference to me between Mr. Doan and Mr. McDonald and Utano is that Mr. McDonald and Utano gave very blunt, critical testimony, whereas Mr. Doan obfuscated, prevaricated, didn't answer questions, and gave every indication of trying to defend the party line. And I get the same impression here that you who are subject to the leadership of CBSA are looking at one set of allegations against one set of individuals and not against others. Maybe the best way to go from that is to ask you, sir, about your own reporting chain of command. You have characterized your investigation as independent, but you're not independent, are you? You're part of the department. You're subject to the authority of the department, and you're movable, reassignable at any time. Is that correct?
Of course, I do not have the independence of the OAG or the procurement ombudsman, for example. But I do have the space and time to conduct my work independently within the agency.
Okay, you would like us to believe that you have space and time to act independently, but substantively in terms of your role, you are not independent. There are no independent attributes about your role. And you even told us that you're informally providing information to your superiors at CBSA on an ongoing basis.
To wrap up,
you are
please.
not an independent investigator. You are their investigator, subject to the authority structure within CBSA. Do you think that compromises the integrity of your investigation?
Very, very brief answer, please.
It is normal for departments to investigate matters that occurred within their departments.
Thank you very much. Mr. Kuzmirchuk, please.